You have received a summons to the Court of Criminal and Penal Prosecutions. You have either been a victim of a crime, have witnessed a crime, or have information that may be of value to the court in a criminal case. You may have many questions about appearing before the court, and the thought of testifying can cause stress and anxiety. These reactions are quite normal and are experienced by the majority of those called to testify. As a witness, you'll be asked to play a key role in the administration of justice. This video will expose your role as a witness during the course of a typical day at the criminal court and will explain the rights and services available to you. Every courthouse maintains a secure location for the care of victims and prosecution witnesses. Special constables are also present in the courtrooms and corridors. Let them know immediately if you're concerned for your safety. The reception area for victims and witnesses offers liaison and support offered by the Crime Victims Assistance Center, while isolating you from the accused and his or her relatives. Persons that you have chosen to accompany you to court are also welcome in this area. The counselors at the Crime Victims Assistance Center welcome the opportunity to answer any of your questions and ease your mind. They will direct you to the appropriate judicial counselors, whether it be the prosecutor or the police officer working on the file, so you can review the statement you gave to police officers, ask questions, and familiarize yourself with the orientation of the file. Docket call. Court begins with a docket call. The docket call sets the priorities and reveals the direction of the scheduled cases in the courtroom. Following the docket call, different scenarios are possible. It's possible that the case will be remanded to another date, or that the case is settled and you will not have to testify, or you will have to testify. To ensure that court runs smoothly all day, and to enable all persons related to the court records to meet, all witnesses are asked to arrive at the designated location for 9 a.m. Your testimony in criminal court. Court is open to the public. You must maintain formality, be polite, and stay as calm as possible during your testimony and while seated in court. The prosecuting attorney is relying on your testimony to illustrate to the court that a crime has actually been committed. If you are one of several witnesses within the same case, the judge will invoke witness exclusion, and you will not be permitted into the courtroom until your name is called. To avoid influencing witness testimony, it is very important that witnesses do not discuss the facts of the case amongst themselves. Upon being asked to introduce yourself to the courtroom to testify, you must advance to the witness stand and you must swear to tell the truth. Then, the clerk will ask for your name, your age, occupation, and address. If you wish, you may request that your address remain confidential. The interrogation. To begin with, you'll be questioned by the prosecutor, who is not your personal attorney. The prosecutor represents the interest of society. The role of the prosecutor is to prove beyond a reasonable doubt that a crime was committed. He or she presents open questions: where, when, who, how, which allow you to describe the event with the most detail and in chronological order. Since the court must be neutral, it is important to understand that as the hearing begins, the only information that the judge has is the sheet that describes the charges. The judge therefore analyzes only the information presented before him as evidence and arguments to come to a decision. This is why it is important to describe the events accurately. Cross-examination. Next, the defense lawyer will cross-examine you with counter-questions. The role of defense counsel is to sow doubts in the mind of the judge that the accused did not commit the crime. The defense lawyer will ask questions in different ways in an attempt to disrupt your concentration or your resolve and to test your memory. The defense lawyer may also attempt to minimize the seriousness of your actions or reactions. So, it's important that you remember that the defense lawyer doesn't know you. Do not take his questioning personally. You may also be asked close questions, which are not necessarily related to the event, but are used to assess and demonstrate your credibility as a witness. During cross-examination, you don't need to offer details of the event, having done so with the prosecutor. Know that the court expects you to answer honestly to the questions that are asked. The prosecuting attorney will object to questions on criminal and penal grounds if they don't appear relevant. Keep your answers simple, and if you feel that certain details or clarifications must be made, feel free to add them to your answers while questioned by the defense lawyer. Your role as a witness. As a witness, your role is to answer, to the best of your knowledge, all questions that you will be asked. It is perfectly acceptable to answer your questions with, "I don't know," or "I don't remember." By contrast, avoid answers such as, "It seems to me," or "I think," if you are certain of what you say. The only time that you should not answer a question is if you hear an objection. When an objection occurs, you must await the decision of the judge as to whether you should answer the question or not. It is important to listen to the entire question until the end and then to take time to think. Sometimes lawyers can ask a question which includes inaccurate information. It is important to correct the information within your answer. If a question is not clear, you can ask for a clarification or to have the question stated differently. It is important to direct your answers toward the judge. Look to the judge when answering questions. Following your testimony. Only when the judge tells you that your testimony is complete can you leave the witness stand. Several options are offered to you. You can return to the victim's and witness's room to wait for the judge's verdict, or remain silently in the courtroom unless otherwise instructed by the court. When the prosecution case has been entirely presented, the accused may decide to present a defense, and in doing so, the accused can choose whether to testify or not. Remember that all witnesses are also cross-examined. The prosecutor will ask questions of the defense witnesses, just as the defense counsel did with you. If you believe that your emotions are too high and that you'll find it difficult to contain yourself, it would be best to leave the courtroom. It is important to remain calm at all times while in court. When all testimonies are concluded, each lawyer will present arguments to direct the judge's attention toward the facts of the case in what are called final arguments. The verdict. If you'd like to hear the judge's verdict, you can remain in the room at your discretion. This could help you to understand why the judge made this decision, because the judge always explains what led him to make a decision. It's possible that you may not agree with the decision. It's important to remember that just because the judge acquitted the accused, it doesn't mean that he did not believe you, but rather that the judge has determined that a reasonable doubt existed regarding the innocence of the accused in this case. Remember that the judge doesn't know you, and the decision to come to this verdict has been based solely on what was said at trial. The sentence following the verdict may be delivered the same day or at a later date. It is your right to request assistance from the Crime Victims Assistance Center to explain the sentencing matters. If a prison sentence is imposed, the Crime Victims Assistance Center will provide information on services available from correctional services. Before or after your visit to the court, do not hesitate to contact the Crime Victims Assistance Center if you want information regarding a file or if you need support and information. CAVAC, Crime Victims Assistance Center, provides various support services and information to all victims, witnesses, and their relatives. Services are free and confidential.